morning, everyone, and thank you for joining our Junior Energy In-House Lawyers webinar series. My name is Ailey McSherry, and I'm a senior solicitor in the Disputes and Regulatory team here at Burness Paull, working in our health, safety and corporate crime team, with a particular focus on fraud and economic crime. I've worked on a range of investigations and compliance matters relating to bribery, fraud, failure to prevent the facilitation of tax evasion and other economic crimes. And I'm here to tell you a little bit more this morning about some of the upcoming risks and how best to manage these. Before we get started, a little bit of housekeeping. Once you've joined the session this morning, please ensure that you keep your mute button selected to limit any background noise during the session. Please also note that today's webinar won't be interactive, so contact me or your usual Burness Paull contact with any follow-up questions if you'd like assistance on any of your projects as well. My contact details will be provided at the end of the webinar. Today's webinar will be recorded and is being recorded at the moment. If you have any queries on this, please check out our privacy policy on the Burness Paull website, and you will receive a copy of the recording over the next day or so. So, what are we going to cover in today's session? This morning's webinar will focus on corporate criminal liability, economic crime, and managing management risks. In terms of the agenda, I'll cover economic crime risks in the energy sector, the current regime, some upcoming changes, and how best to manage risks internally. Turning first to some key legislation. There are a few pieces of legislation up on the screen in front of you. 3 of these are what's known as failure to prevent offences, or introduced what's known as failure to prevent offences. 1 deals with self-reporting, and the others deal with some significant changes to how corporate criminal liability is assessed in the UK. So the Bribery Act 2010 came into force in 2011 and introduced relevant bribery offences, as well as a failure to prevent bribery offence, which applies to corporates. Organisations have a defence to failure to prevent bribery if they have adequate procedures in place to prevent bribery. The Criminal Finances Act 2017 does similar, but with respect to tax evasion. So it introduced the criminal facilitation, the failure to prevent the criminal facilitation of tax evasion offence, and a defence of reasonable procedures. The Economic Crime and Corporate Transparency Act 2023 did the same for fraud. So that introduced a failure to prevent fraud offence that applies to relevant corporates and a defence of reasonable procedures. The other pieces of legislation on the screen include the Criminal Justice and Licensing Scotland Act 2010. That applies only in Scotland, but it sets out a really important provision for businesses with a Scottish presence, where 2 or more individuals are involved in the commission of a serious organised crime. This piece of legislation requires organisations to self-report that crime has occurred and has been detected. Serious organised crime is quite a broad definition and would include offences like fraud. So it is relevant to corporates to have this on their radar. And then the Economic Crime and Corporate Transparency Act again, or ECTA as it's known for short, and the Crime and Policing Act 2026 also introduced some significant changes in how senior manager liability is assessed in UK criminal law. So both of them introduced what's known as a senior manager offence, which means that where senior managers carry out certain offences, the corporate can be liable for that. And each of the pieces of legislation on screen with the exception of the Criminal Justice and Licensing Scotland Act, all have provisions which apply in both Scotland and England and are relevant for today's purposes, all around corporate liability. So here's the kind of legislative framework, but why is this relevant to the renewable energy sector? Renewable energy has higher risks in relation to fraud and corruption than many other sectors. There are prime conditions for economic crime offences to take place across different phases of a project, from acquisition through construction, operation, decommissioning and repowering. economic crime risks can touch at any phase of a project and really should be considered across the life cycle of any renewables development. Particular risks include things like large financial investments, complex supply chains, a heightened focus on ESG credentials, and frequent contact with public decision makers. For example, knowingly misreporting ESG data or data relating to curtailment to lead to increased investment or curtailment payments could constitute fraud. Tax evasion is a specific known and understood risk within the construction supply chains, and renewables projects involve significant construction projects and the use of many, many subcontractors where this issue may arise, and expose renewables developers to this risk. There is also frequent exposure to public authorities through planning and through lobbying, which expose organisations to that risk of frequent public official contact, which may lead to bribery and corruption. Further, lots of renewables businesses carry out international investment as well into other jurisdictions to install new projects, and jurisdictions that don't have the developed compliance frameworks that the UK does, or which are known to have increased risks of corruption, mean that organisations, even within the UK, can be held liable for activities in those jurisdictions where they engage issues like bribery and corruption. And these risks can lead to significant impacts for the company, including around the commission of criminal offences of bribery, embezzlement, trading influence, and those associated with manipulation of the policy framework and also fraud. But what does any of this mean? The consequences of breach of the legislation that I've set out before and other relevant economic crime legislation can be really significant. For the failure to prevent offences and for other criminal offences, corporates may receive unlimited fines, which would not be covered by insurance because they are criminal in nature. There's also serious reputational consequences that can go alongside that. For individuals who are involved in the commission of any relevant offence, they themselves could also receive an unlimited fine, and for certain offences like fraud and like tax evasion, they could receive up to life imprisonment. For individuals who are convicted of an indictable offence, so that would include things like bribery, tax evasion, fraud, they may also be subject to a director disqualification order by the court at the time of their sentencing, which would stop them from acting as a director of any other relevant company for a set period of time. And further, proceeds of crime confiscation orders can be made, which would have a huge financial repercussion for those that the confiscation orders are made against. There are a few examples on the screen here of some recent prosecutions, deferred prosecution agreements, and investigations in the UK for relevant economic crimes. And as you can see, there is a considerable amount of public interest in prosecuting these at the moment, and in reporting on them, which can lead to significant reputational harm where allegations are made. So I touched on this briefly earlier, but there are two key models of corporate criminal liability in the UK now. There is the failure to prevent model, and there is the model of senior manager liability. Failure to prevent is a model that was introduced by the Bribery Act in 2011 in the UK. And this model holds organisations criminally liable for the failure to prevent misconduct by their associates, regardless of whether that organisation was aware of misconduct taking place. As I set out on the legislation slide, there is legislation on this in relation to failure to prevent bribery, failure to prevent the facilitation of criminal tax evasion, and failure to prevent fraud. The other model of corporate criminal liability is has changed in recent years. We used to have something called the directing mind and will test. And this meant that prosecuting authorities needed to prove that someone acting as the directing mind and will of a relevant corporate body had been involved in the commission of that offence for the organisation to be held liable. Under ECTA, the Economic Crime and Corporate Transparency Act, this test significantly changed for economic crimes on Boxing Day in 2023. This was replaced by what's known as the senior manager test, where a senior manager commits an offence within the actual or apparent scope of their authority, that organisation will also be guilty of that offence. And the point that makes this relevant for a wider range of corporates is the definition of who is a manager. A manager is not just a director or someone at the top of an organisational chart. This is any individual who plays a significant role in the making of decisions about how the whole or a substantial part of the activities of a body corporate or a partnership are to be managed or organised, or the actual managing or organising of a whole or substantial part of those activities. So this means it is not just the people with senior manager in their name. It means that it's not just C-suite, but it is those who have actual day-to-day managerial responsibility over specific parts of the business, not even the whole business. This can mean that individuals that you wouldn't necessarily consider as being senior managers end up exercising that role and could therefore bring the corporates within the scope of the relevant offence. So under ECTA, currently the economic crimes where senior manager liability applies include fraud, theft, false accounting, false statement by directors, concealing criminal property, terrorist fundraising, bribery, and financial sanctions, and many others, but that's just to name a few. This is currently a wide range. However, with the Crime and Policing Act 2026, this received royal assent on Wednesday last week and is very hot off the press. This act extends the senior manager test to all criminal offences under UK law. In practice, this could be a huge range of offences. For example, and these are just examples, a senior executive speeding to a meeting that they've been told that they can't miss. The corporate could be convicted of a related driving offence, where a security manager has been told to keep people out of a site at all costs. If they assault someone who has entered into that site, the company could be liable for that relevant assault. Where a developer has been told they need to do whatever they need to do to make a project profitable. If they commit arson and associated insurance fraud, depending on the nature of their role, that could possibly be considered to be within the scope of their authority. And where those are individuals are involved in business development and there are drugs present at those events, those drugs offences could be deemed to be within the actual or apparent scope of those individuals' authority. These are just examples, and we're yet to see how this will be implemented in practice, but it goes to show that the Act makes significant changes to the risk profile of corporates and how they should be thinking about corporate crime and corporate criminal offending. And not only is it the carrying out of certain offences by those senior managers themselves, but where those senior managers encourage, assist, incite, aid, abet, procure, counsel others within their teams or others related to them to do so. And this could also lead to senior liability, to the application of the senior manager liability test and corporate criminal liability attaching. Unlike the failure to prevent offences that I mentioned at the beginning, for the senior manager's test, there is no reasonable or adequate procedures defence which would apply to provide a defence to the corporate body. And as such, it's really important to take a different preventative approach where policies and procedures are in place. The organisation should be really strongly committed to these and committed to being very clear around the persons within their organisation that do have senior manager roles the limits of the authority that they have, and how this is managed and controlled. But the senior manager's test doesn't stand alone. Compliance is connected, and although reasonable or adequate procedures under the other legislation I've mentioned are not a defence to the senior manager liability provisions, it is really important to ensure that there is a comprehensive compliance regime in place, because this overall minimises the risk that these offences can be carried out by senior managers in the first place. And as in-house legal counsel, it is really important to ensure that you understand how all of these compliance regimes fit together and how they work within your organisation's operations. So part of that is understanding the key relevant guidance which exists across the kind of corporate criminal landscape. So the first three pieces of guidance that are shown on the screen are guidance around what reasonable or adequate procedures should involve to provide organisations with a defence under the Bribery Act, the Criminal Finances Act, and the and under ECTA for failure to prevent fraud. But there is other further guidance related to how self-reports, investigations, deferred prosecution agreements and prosecutions are considered. The Scottish Crown Office and Procurator Fiscal Service self-report policy, and the English equivalent, the Serious Fraud Office and Crown Prosecution Service corporate prosecution guidance, both set out considerations that prosecutorial authorities will have in mind when they are making a prosecution decision or another related charging decision. A further part of the guidance that you should have in mind is the Serious Fraud Office guidance on evaluating a corporate compliance programme. Whilst the Serious Fraud Office does apply across the UK for certain things, this is of less relevance in Scotland, but it sets out considerations that the SFO would apply when assessing whether an organisation's compliance programmes are sufficient for the purposes of one of the failure to prevent offences, or for another offence where the adequacy of policies and procedures in place need to be assessed. And this sits alongside the guidance, the specific guidance on reasonable and adequate procedures for bribery, fraud and tax evasion that are set out above. So if you are looking at your internal compliance programs and trying to assess whether or not these are adequately robust, it's important to take all of these into consideration together. And at the bottom, can we expect guidance under the Crime and Policing Act? This has been mentioned as part of the progress of the Act, but we're yet to see any kind of timescale for publication of this. The Act passed last week on Wednesday and is yet, as of the time of this webinar, to be uploaded to legislation.gov. So we might be waiting for some time for any relevant guidance on this to be published. But once you have got your head around the variety of pieces of guidance that there are in this sector, it's important to look at the rest of your compliance framework. As an organisation, one of the key foundational elements of a good compliance programme is having an adequate risk assessment in place. This helps you understand what risks are actually relevant for your organisation's activities and whether the policies and procedures that you have in place are sufficient to control those identified risks. And whilst adequate or reasonable procedures are not a defence to the senior manager offences in the same way that they are for the failure to prevent offences, ensuring that these policies and procedures are in place is a helpful mechanism to ensure that you're clear about the limits of acts that would be within an individual's authority, and that those are not part of your accepted organisational behaviour, which should help minimise the risk that such offences are carried out. And that overall will reduce that risk. Once you have your risk assessment and your policies and procedures in place, it is very important that these are regularly and robustly monitored and reviewed and updated as required, and that you have an investigations process in place which is fit for purpose, can be accessed and used where there are allegations of non-compliance or you discover some instance of criminal conduct. So more of these elements apply to the whole business, not just legal, but what can legal do to support that compliance? It's important to explain relevant compliance risks to the business, ensure that you have adequate control arrangements in place, which include auditing, testing, and training. You incorporate compliance checks into project checkpoints and gating, ensuring that this doesn't just cover financial or deliverable metrics. Making sure that you understand the relevant guidance and relevant reporting requirements so you can assist the business where issues do arise, and to assist them to ensure that their compliance processes and procedures are robust and fit for purpose, and that your procedure for investigations is clear. It includes when legal privilege would be considered and applied, and how communication with regulators would be carried out. Across all of these points, the main thing is communication. Communication is key to ensuring that your organisation understands all of the relevant risks which apply. It's key to ensuring that policies are understood and followed across the business, and that risks, where identified, are communicated back to legal, as well as incidents where these occur, and that these can be adequately investigated. The most important thing for legal is to bring the business with you. There's a few questions on the slide that could inform your approach on this, including checking that the business know what's going on, that they know what relevant policies and procedures say, that they know how to report issues that arise, and that the business take appropriate action where issues are identified, and that legal work with relevant teams to understand the specific risks and constraints which might apply to their activities. So this seminar was planned and written a little while ago, before the Crime and Policing Act received royal assent. Whether this is perfect timing to have run this session, you can decide, but we didn't want to cancel it. We wanted to bring you the information that we had. As I say, the legislation is pending publication on legislation.gov. So once this is available, we will be providing more information. So please sign up to our relevant blog lists and mailing lists for further information on that as it is published. But the Act itself received royal assent last Wednesday on the 29th of April, and section 254, which at the moment is the relevant section, is due to come into force on the 29th of June 2026. This one section deals with the amendments to the senior manager test in corporate criminal liability for all UK regular crimes, expanding this beyond the scope of just economic crimes. The latest version of the bill is 574 pages long. The majority of this deals with other crime like knife crime and sort of other related provisions. It is only this one section that deals with the corporate criminal liability position. So it might take a little moment for the government to get this uploaded to legislation.gov and for any guidance which is predicted to be published as well. But organisations at the moment have a couple of months to assess the impact of the legislation and the sufficiency of your current compliance regimes to ensure that where there is a risk of senior manager liability for specific criminal offences, that these are adequately controlled by the processes and procedures that you've got in place. As I say, this is very much the cutting edge of legislation publication. We are awaiting further updates, and we will communicate those more generally as that information is available. So please stay in touch if you want to find out more about that. And on that, that brings us to the end of today's session. If you'd like to hear more about any of the topics covered today, or if you have any specific questions for me or for the broader Brown Ball team, please reach out to one of us and we'd be delighted to help. As mentioned at the beginning, this session has been recorded and you'll receive an email with a link to the recording of the session by early next week. Our upcoming sessions are shown on this next slide. They are on construction contracts and energy consenting and biodiversity. Please use the link provided to check out our next sessions and book your spot in advance. And thank you very much for joining today's session, and we look forward to seeing you at future sessions.